Tate Hubbard versus Southeastern Freight Lines, Inc., and Samuel Contreras.
Good afternoon, Your Honor. Jesus de Luna here for the plaintiff.
Good afternoon.
Kennedy Gerard here on behalf of defendants and Mary Henderson as well.
And we're here on defendants' plea to the jurisdiction.
That would be correct, Your Honor.
Okay, you may proceed.
Your Honor, this plea to the jurisdiction was filed on behalf of our clients because a motor vehicle accident occurred in June of 2023, on June 2nd of 2023. However, when the petition was filed, it says that the plaintiff, Mr. Hubbard, was seeking future damages. It said that he would suffer from ailments in the future. However, Mr. Hubbard passed away 65 days before that petition was actually filed. Because he was deceased, but the petition was filed as if he was alive, there's no standing for the petition to be heard today. Standing is an essential element of subject matter jurisdiction. When the Texas Supreme Court has said time and time again, if there's no subject matter jurisdiction, then the court cannot hear the claim. Opposing counsel filed a response a couple of hours ago, and I believe that he knows that the petition was filed as if his client was alive, and now that there's this huge jurisdictional defect. But if you're looking at the foundation here, it's a negligence claim filed on behalf of somebody who did not have standing to do so. Therefore, there's no subject matter jurisdiction, then the case should be dismissed. Based on the response that we received, though, it seems as if there is a dismissal, because there should be one, it should be done without prejudice. But doing this would just be a workaround the fact that the statute of limitations has ran for this claim, being that the motor vehicle accident, which allegedly resulted in injuries, was in June of 2023. We do sympathize with Mr. Hubbard's family, being that they're grieving, but this sympathy shouldn't be used as a blanket to cover up the fact that a frivolous lawsuit was filed. Opposing counsel from our purview didn't know that his client had passed away until our office notified him that Mr. Hubbard had passed away. And now the statute of limitations has ran on the claim. In the response, they throw around hypotheticals like wrongful death suits and survival actions, but this isn't a wrongful death suit. Mr. Hubbard did not pass away based on injuries as a result of the June 2023 accident. Mr. Hubbard passed away in an unrelated motor vehicle accident in March of 2025, and then a petition was filed on his behalf in May of 2025. And this case should be dismissed with prejudice because the statute of limitations has ran. The case is captioned as if Mr. Hubbard brought the case himself, and they seek future damages as if he's alive.
We don't have, we know that we don't have standing. We figured that out after the fact, right? We were trying to get to contact Mr. Hubbard, and we just couldn't. So statute of limitations was on top of us. That's why we filed. We didn't know that he had died until, of course, defense let us know. So our stance is we don't have. I mean, we know we don't have standing. We don't have an issue with the dismissal. The only thing is that, and we don't represent the family or the wife. So our only thing here today, and to respectfully ask the court that, again, we don't have an issue with dismissing the file, but it's one that we want to make sure it's done without prejudice. Just because there's independent persons here, or heirs, right, that might be able to bring a survival claim in the future.
Okay, so am I understanding you clearly that you're not really objecting to a dismissal as long as it is without prejudice?
Correct, Your Honor.
Okay, anything else, Mr. Gerard?
Yes, again, opposing counsel is throwing around the hypothetical survival issue. And again, we sympathize with the fact that Mr. Hubbard passed away, but we asked the court that it be considered that we did a simple Google search and found out that Mr. Hubbard passed away before the petition was filed, the same thing that opposing counsel could have done before he filed his petition if he was trying to get in touch with his client. It's not our fault that the petition was filed not by the right person, but that's the case here. And now the statute of limitations has run, so we believe that there should not be any subsequent claim that is able to be brought based on the accident that happened on June 2nd of 2023.
Okay, under the circumstances, the court is going to grant the plea to the jurisdiction and dismiss the claims without prejudice.